The Nonhuman Rights Project is an organization primarily made up of volunteers, though we had some paid staffers, and our purpose is to try to persuade common law courts that non-human animals are legal persons with the capacity for legal rights, including their fundamental rights, such as bodily liberty or bodily integrity. The Nonhuman Rights Project, is engaged in an open-ended strategic litigation campaign, and so these three cases are not like one-offs. This is really the first salvo in a strategic litigation campaign that we fully intend is going to lead to the legal personhood of one or more non-human animals. We're talking right now about those animals who are autonomous, who are the most cognitively complex. So our first lawsuits, which were filed in December of 2013, have to do specifically with captive chimpanzees. The lawsuits that we filed in early December 2013 were aimed at chimpanzees who were in captivity, in fact all of the chimpanzees in the state of New York. And there are 4 of them held in 3 different locations. 2 of them are in private hands and 1 of them is at a state university. And we are seeking a common law writ of habeas corpus ordering that the chimpanzees be declared legal persons who then have the capacity for legal rights, and that the legal right they be given is the right to bodily liberty, and we want the judge to order them to be sent to the North American Primate Sanctuary Alliance, who will evaluate each of them and send them to the appropriate sanctuary in the United States. Our legal theory, our main legal theory is that we are using a common law writ of habeas corpus, which is the key to the courtroom, which opens the door, and then we go in to argue to the judge why indeed they should be legal persons and why they should have this sort of a fundamental right. And we're making 2 sorts of arguments. One argument is as a matter of liberty, and we argue that it is a sufficient condition for these chimpanzees to be so cognitively complicated that they are autonomous, that they are self-determined, that they are self-aware, that they can choose how to live their own lives. And we then point the New York courts to their numerous statements for 100 years or more, in which they talk about how much autonomy is valued. Now they speak of it in terms of human beings, but we don't see why it should be limited to human beings, that an autonomous being who can live his own life, whether he's a chimpanzee or he's an orca or he's an elephant or a human being, it shouldn't matter. The fact is that all of these creatures, including myself, were all so cognitively complex that we are autonomous, that we indeed can choose to live our own lives, and a fundamental part of that is simply the ability to be able to move around, to go where we want, at least to some reasonable degree, and to hold chimpanzees in captivity in cages so fundamentally undermines their interest in autonomy that they should, like us, have a fundamental common law right that protects their autonomy and bodily liberty. And so we're trying to get them out of the cages and to the next best thing to Africa, which is some of these sanctuaries that are part of the North America Primate Sanctuary Alliance. Yes, this is really the first time, certainly in the English-speaking world, in which anyone has demanded that a court recognize that any non-human animal is a legal person who has the capacity for any legal right at all. In our memoranda, we addressed what we thought might be a concern of people, that they would believe that the term legal person was synonymous with human being. And we show that it is not. A legal person is a container for legal rights. So someone who's not a legal person cannot, by definition, have a legal right. A legal person is someone who has the capacity for a legal right. So we could view a legal person, say, as kind of like a legal cup, and then a legal rights are kind of in a legal pitcher. And so first you have to have the legal cup, the container that can hold a legal right. And then we take the pitcher of legal rights and we begin to drip them in and say, can they have this right? Can they have that right? So if they're not a legal person, you're just dripping rights onto nowhere. There's nothing that can hold them. If they are a legal person, you drip the right in, as we're doing now. We say bodily liberty. And then we argue with the court first to establish the fact that the chimpanzees are legal persons, they are the cup, and that this right, this fundamental right to bodily liberty, they should have. And we point out to the court that certainly in the United States, there are all sorts of non-human legal persons. There are corporations and ships and partnerships and states and counties, things like that. But that in other common law jurisdictions, English-speaking jurisdictions, they go even farther. The Indian Supreme Court has held that the holy books of the Sikhs is a legal person. A pre-independence court held that a Hindu idol was a legal person. In 2012, there was a treaty between the Crown and the native peoples of New Zealand in which they agreed that a river was a legal person. And so legal person means that the legal system thinks enough of the entity that it should have the capacity for some kind of a legal right. That's all. Does not mean a human being. Sometimes I talk about the fact that when a legal thing comes into a courtroom, a legal thing is an entity that lacks the capacity for all legal rights. If they succeed in being characterized as a legal person, in which they become like a container for rights, then I say they've undergone a legal transubstantiation, which obviously I'm referring to a Catholic transubstantiation, in that they come into court looking a certain way, but they are a legal thing. They have no rights at all, no capacity for them. They walk out. They look the exact same way. But as far as the law is concerned, they have been transformed. They are now not an entity who is invisible to the civil law. They are highly visible, and their interests and their rights will be paid attention to. But if you look at them, they would seem the exact same. Well, the specific cases we're bringing claim that these 4 chimpanzees have the kind of autonomy that is sufficient for legal personhood. And right now, that's all we're claiming. And we'd like to persuade the courts that indeed those 4 chimpanzees are legal persons and they have the right to bodily liberty that is protected by a common law writ of habeas corpus. And so what we're trying to do is see whether we can persuade the courts to do that. And once they've done that, we have to see what they accepted, what they didn't, how broad they're willing to go. But we think it's reasonable to say right now that any entity who is autonomous, is self-aware, can self-determine, can choose how to live their lives, those entities clearly have what it takes to be characterized as a legal person with a fundamental right to bodily liberty. We studied chimpanzees thoroughly. Attached to our petition for a writ of habeas corpus are affidavits from 9 of the most prominent primatologists in the world, not only the US, but Scotland, England, Sweden, Germany, Japan. So we are thoroughly convinced that indeed at least chimpanzees have the autonomy that is sufficient for legal personhood. And as with respect to other non-human animals, that's going to have to wait for other cases and our consultation with other experts. We don't assume anything. We are entirely an evidence-based organization. No matter what we might want, that's one thing, but we are lawyers and we have to be able to prove what we are saying we want and what we're saying is true. No one has, certainly not in the English-speaking world. There was a case, but I don't think it even went to court. Because the judge in Salvador, Brazil in 2005 was asked whether a chimpanzee named Suika, who was in a zoo, could be ordered freed pursuant to a Brazilian statutory version of a writ of habeas corpus. And Suika died on the day that the judge was supposed to render his decision as to whether or not he would issue a writ of habeas corpus. So that was a try. No one has ever done what we did this week, which is actually go in and for the first time actually have a 1-hour oral argument in front of a judge in which we're demanding legal personhood for our chimpanzee. The 4 chimpanzees who are the plaintiffs, the petitioners in our our case, kind of from west to east, there is a chimpanzee named Kiko who lives in a cage in a cement building in Niagara Falls, New York. He was living with another chimpanzee until about 3 weeks ago. That chimpanzee died, named Charlie. By the way, there were 7 chimpanzees in March of 2013. One of them we knew died in April. That brought us down to 6. One of them died in September. That brought us down to 5. Charlie died in October. That brought us down to 4, which is one of the things we're very concerned about, is that 3 of the 7 chimpanzees in the state of New York have indeed died in the last 7 months. Kiko is now by himself in Niagara Falls. Then moving a little bit further east, there is a chimpanzee named Tommy who is also living and has lived for a long time by himself in a small town in New York State. I went to see him. We have seen him. We have photographs of Tommy. We think that at one point Tommy was used in the entertainment industry, but we're not 100% sure. We move further east, and there are 2, I think they're subjuvenile chimpanzees. I think they're only 6 or 7 years old, who are being kept at Stony Brook, and they're being used in biomedical research, locomotion studies. We don't know. Stony Brook has stonewalled us for a couple months. They would not confirm that the chimpanzees were there or not there. We eventually used our sources, asked around, and we were, on the day this week in which we filed suit, I think we were 95% sure that Leo and Hercules, the name of the 2 chimpanzees, were indeed at Stony Brook, and now it's been confirmed they are indeed at Stony Brook. We spent 5 years running dozens of legal questions through all 50 states. And then that's why it took us so long. Really thousands and thousands of hours we have spent writing memos, researching issues, and carefully comparing all 50 states. And slowly over the 5 years, we would toss out states. And about a year ago, in November of 2012, we narrowed our search down to 6 states. And in March of 2013, we narrowed it down to 1, and that was New York, for all kinds of reasons. We liked their habeas corpus statute. We liked their, even more so, the way they clearly embraced the common law writ of habeas corpus. I had written a book called Though the Heavens May Fall in 2005 about a very famous slave case called Somerset versus Stewart, in which a black slave named James Somerset in 1771 sued for his freedom, and in 1772, Lord Mansfield, who was the Chief Justice of the Court of King's Bench in London, said that slavery was so odious that the common law would not support it, and ordered him freed. And I wrote that book because the way in which James Somerset's lawyers used the common law writ of habeas corpus was both a metaphor for how we intended to use it and a blueprint. And New York courts adopted the Somerset versus Stewart case. They in 1775, they embraced the 1772 case by adopting the common law of England. And in a very famous case, Lemon versus People in 1860, they actually used it in a slave case. And so we really like that as well.